So let's start with the meaning of partnership. Partnership seems to be a very interesting word. Partners means the word itself says something, means where there are more than one person is involved. Section 4 of Partnership Act defines that partnership is the relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. This definition conveys a few features of a partnership, where we can say there must be two or more persons who should enter into an agreement to carry on a joint business and to share the profit of that business. And this business relationship is called as partnership. The persons who will enter into this business on in this partnership and who will work with each other would be individually called as partners and would collectively would be known as a firm. What are the essential features of a valid partnership? There must be an association of two or more persons. One person cannot be a partner of himself, so there should be at least two persons to form a valid partnership. The person, yes, should be competent to enter into a contract. That means they should fulfill all the conditions of a competent party to enter into a contract. Let's see the example. A, B, and C were three partners carrying on spare parts business in partnership. Subsequently, A and B retired from the firm and C continued the business. So, in this case, there is no partnership as C alone cannot carry on the business. Indian Partnership Act otherwise don't give any provision regarding the maximum numbers of partners in a partnership business, but section 11 of Companies Act fixes the maximum number of partners in a partnership business. The section 11 of Companies Act says that in case of banking business the number of partners should not exceed 10, and which cannot be exceeded than number of 20 in any other business. But according to section 11 of Companies Act, if this number exceeds in any partnership, it would become an illegal association, and then if even the partners want to continue with the business, they may register this partnership as a company under the Companies Act 1956. It would not undergo under the Partnership Act. That means, in short, Partnership Act doesn't define the maximum number of partners, but section 11 of Companies Act 1956 defines it: 10 in case of banking business, 20 in case of any other business. Second point is there must be an agreement. Section 5 of Indian Partnership Act defines that the relation of partnership arises from contract and not from the status. Means there should be any express or implied contract between the partners. Express is always considered the priority in case of partnership. All partners must enter into an agreement. If any partnership comes into existence without the agreement, it would not be considered as the partnership business, and the partnership should come out of the agreement, not by the status or not by operation of any law. And that's why it distinguishes the partnership from a co-business and a joint Hindu family carrying on the business. In joint Hindu family, the business comes by the status, comes by the operation of law, but not by the agreement. The agreement to constitute partnership may be express or implied, as I have already said. So this is clear from the case of Abdul versus Century Woods Industries. So here, what are the facts of the case? A and B, two brothers, were living together with their father C. On the death of their father, they inherited certain properties which they did not divide. They sold a garden and invested this amount in a separate timber business. There was no partnership agreement, but it appeared that they intended to share the profits of a timber business. The business failed, and the question arose about the distribution of liabilities. It was held that there was partnership and they must bear the liabilities as partners. In this case, there was an implied agreement of partnership which arose from the conduct of the partners because they have joined that business with an intention to share the profits of the timber business. They have implied contract, they have implied agreement of partnership between them. Third, under the partnership is there must be some business. The partnership business must be carried on to carry on some business. Here, business means some lawful activity, the result of which would be in profits. There may be some losses, but the objective to running that lawful business is to earn the profits. It also includes any trade, any occupation, or any kind of profession. It is here important to mention that the objective of carrying business may not be long and permanent. It may not be long and permanent undertaking, but the partnership business can be for a single business or for a single venture or for a single undertaking. Say A and B agreed to produce a film and share the profits of hiring it out. So it was hold to be the partnership. That means if the partnership was just for producing a film and to get the profits out of it, it is a valid partnership. To constitute a valid partnership, the business must be in existence. Means anything which is to come in the future does not result into a partnership. Means when the agreement for partnership was done, there must be some business carrying on in existence. Let's see the case of R. Sarna versus Rubin. A deposited a sum of money with the Kanpur Municipal Board in the name of a civil engineer company. The object of this deposit was to obtain a license for producing electricity in partnership with another person B. The municipal board refused the license and the money was refunded. A claimed the whole money. B contended that it was a partnership money and it should be used to pay partnership liabilities. The court held that there was no partnership at all because the business didn't come into the existence. It is to be operated in future. That means the condition that the business must be in existence at the time of the agreement makes this point void, that the money should be paid for the partnership liabilities. Next point is there must be sharing of profit. When more than one persons join to do any business, the objective definitely would be sharing of profits. Here, profit means the net profit, the surplus money after paying all the expenses of the partnership business. And there must be a specified agreement to share the profits in any specified ratio, or if in absence of any contract they can share the profits in equal proportion. If any person, any partner is entitled to whole of the profits of the partnership, this is not a valid contract of partnership. So let's see the example. A agreed with B, a goldsmith, to buy and deliver gold to B. They further agreed that B shall make the ornaments of such gold which shall be sold. They shall share the resulting profits and losses. In this case, A and B are the partners because they are sharing the profits of the business of the partnership. Sharing of profits also included sharing of losses. It's not necessary when the business is done, when the activities in the business are done, there would definitely be profits. There may be losses. So the partnership business also include the agreement for sharing of losses, and it is not necessary that all the partners may share the losses. Any partner may be there if there is a contract, there is an agreement to that the particular partner will not contribute for losses. It is possible a person may be partner only for the shares of a profit. A person can work only for profits, but whole of the losses would not be bear by the a single person. The sharing of profits is only a prima facie evidence of existence of partnership and not the conclusive test. Means it is one of the conditions of the partnership that they are meeting, the partners are meeting for sharing of the profits. And that's why we can say that everyone who receives the profit is not a partner in a firm. They may have the different interest, are also known as non partnership interest in the business, so they may not be the partners who are getting the profits. Now it becomes important to explain that what is the meaning of non partnership interests. Non partnership interest, section 6 of the Partnership Act explains it. Non partnership interest includes joint owners sharing profit or gross returns, money lenders, if receiving profits out of the business, they are not the partners, servants or agents receiving the part of the profit, they may not be considered as partners, widow or child of a deceased partner. Let's suppose any partner has died, any partner is a deceased partner of the partnership. If any widow or any child of that deceased partner is getting the share out of the partnership, they may not be considered, they are not the partners into a partnership firm. And similarly, seller of the goodwill, if someone has sold his or her goodwill to someone else and he is getting now the share out of the profits made by the partnership firm, he cannot be treated as a partner in the partnership firm. That means every person who is receiving the profit is not the partner. It depends upon the agreement that how he is sharing the profits of the business. Next point is there must be mutual agency between the partners. The agency relations means the business of partnership must be carried on by all the partners or by partners acting for all other partners. Means all the work done by one partner should be like this. It can make the other partners, the firms, the liable to the third parties. Means a person must not act for himself alone, he should work for all the partners, for all the firms. Each partner is a representative of all other partner, each partner is a representative of the partnership firm. The partner works as an agent as well as an principal. When one partner works for all on behalf of all other partners, he is treated as an agent, but when he works for himself as a part of the partnership firm, he is treated as principal. Section 18 clearly explains, subject to the provisions of the act, the partner is the agent of the firm for the business of the firm.